Well, hello there and welcome again. If it's your first time, this is the Employment Law Show. Good to have you along on the show. And if you've come back for more than one, it's good to have you back. Always like you hanging with us. Lots to learn on the show every week, so stick around for the next 30 minutes. John Scholes here. And joining me, of course, again, Lior Samfiru, co-founding partner, Samfiru, Tumarkin, LLP, the most positively reviewed law firm in the country. Of course, Lior is an employment lawyer, helping tens of thousands of people across the country get some satisfaction when it comes to their work life and not knowing about employment law rights. There is a very wide berth as far as protection is concerned for you. So that's why we do this show every week, to educate you and involve you in the show, get some feedback and get some satisfaction as far as dealing with your particular matters. You can reach out to Lior anytime. By the way, 1-855-821-5900. Phone number, toll free. Obviously, help@employmentlawyer.ca. And another tool you can use if you've watched this show before, we've referred to it. We go through the metric every time on the show. It's called the Severance Pay Calculator. You can find the Severance Calculator at pocketemploymentlawyer.ca. That website, free and anonymous, and there's so much to be learned there as well. You can use it anytime you like. On the show today, Lior, what you need to know about temporary layoffs. Again, as always, very important topic. We'll get to that in just a bit. Some phone calls from our long-running radio show as well. But we always start off with the week that was. A case of the day. Pal, what's going on with you?
Thanks, John. And you mentioned feedback, and I'm so happy that every single time when we air the show, I get emails with feedback, with comments from people telling me that they learned something new. They maybe felt better about the workplace situation. They understood that there's hope if they're facing a workplace problem and that the law does protect them. And that's exactly why we do this show, because the law can help you. I've said this many times. The law can help you if you don't know what the law is, if you don't actually understand what your rights are. That is the whole purpose of this show. Balance out, to even out that playing field, because your employer probably knows the law. Well, you should know the law as well. You should know your rights, what to do, and of course where to go to if you have a problem. That's where I come in, my team. So certainly, if you want to connect with me off air, we'll give you that contact information so that I can not just tell you what the law is, I can roll up my sleeves, get to work, and help you to enforce your rights. And keep those questions coming. Love having them, love answering them. And let me start off, as I always do, with a situation that came across my desk just over the past few days. Now, you've heard me talk about constructive dismissal often on the show. We'll talk about it later again today. And usually a constructive dismissal happens when an employer takes something away from an employee. Takes your job responsibilities, takes some of your pay, maybe takes away the hours that you had. Well, did you know that you can also have a constructive dismissal when your employer gives you something that maybe you don't really want? Well, I spoke with a gentleman who recently found himself in an interesting situation. His coworker had quit, and his employer came to him and said, "We need you to do both jobs for a while until we find a replacement." So essentially, you're going to be doing two jobs until hopefully someone else is found. Well, obviously, he didn't really want to do this. It meant longer hours. It meant a lot more stress, more pressure, and certainly something that he hadn't signed up for. But, of course, he wanted to be the team player, and his employer told him that it's going to be 1, maybe 2 months until we find someone new and train them so that they can start working, and then you're going to be off the hook. So fine, he continued working, and sure enough, it was as intense and as difficult as he expected. He was working 2 jobs, essentially. Well, after 2 months, he contacted the company and said, "Well, what's going on? You haven't yet found a replacement. I'm still doing both jobs. I'm burning that candle on both ends, and I can't do it." So they give him the runaround. "We're working on it. We'll do it. Don't worry, I'll be fine." Well, after a few more weeks, very frustrated, and I think at his wit's end, he called me, and he wanted to know his rights. Well, if you think about it, John, what we have here is a classic constructive dismissal situation. His employer changed the terms of his employment. He had a particular job. Now he has a very different job. He has double the work. It's not what he signed up for. So in a way, it could be a demotion. Well, this is something different. It's changing the terms of employment nonetheless. So he has a choice now. He can continue working and accept this new reality, or he can treat that as a termination. The company was given a chance. They got a chance to fix it, to hire someone, to have things go back to the way they were. They haven't done that. He can choose to treat this as a termination and get his full severance. So you're at home, if you're in that situation, the same thing applies to you. If your job changes, maybe like this person, you've been given a lot more responsibility. You're doing now 2 jobs. You don't have to accept that. That can be a constructive dismissal, which means you're owed severance. Of course, we all know that severance can be as much as 24 months. If you find yourself in that situation or anything close to that, give me a call.
You know, I mean, this particular case, Lior, it's cut and dry. He's basically been given a second complete job for what we assume is the same money. Does a constructive dismissal, does it have to rise to that level to be a constructive dismissal? What if they added a couple more duties, or they added an extra 2 hours a day to his own job? I mean, would that qualify? You know what I mean?
Well, yeah, absolutely. And that's where the devil's in the details, so to speak. So it's not every single change to your job that's going to be a constructive dismissal. It's a question of whether it's a significant change. And it's going to be different in every situation with every employee and employer, which is why the best advice I can give is if your job is changing, let's talk about that. I want to find out more about your job, your hours of work, how they've changed. And on that basis, I can always say, yes, it's a constructive dismissal, or maybe it's not. But you need to know that information, because the risk of not doing that, the risk of just continuing to work, is you're going to be considered to have accepted it. And then you can't go back. Okay, and you can't say, well, now I regret doing that, so I want to say constructive dismissal now. You have a small window to do that, so certainly don't sit on your rights.
Again, as Lior mentioned, for this or any other concerns, just reach out, make that phone call, right? 1-855-821-5900, help@employmentlawyer.ca is the email address we use. If you go to the website, employmentlawyer.ca, lots of stuff to be learned, and spend some time on the website. There's contact information there as well. There's also a media tab, and you'll find a radio station and, well, TV station broadcast as well, but radio station pretty much across the country, where Lior and I have been hosting a radio show for coming up on 10 years, I think. We get a ton of phone calls every week across the country. We like to cherry pick a few that are really interesting and play them back on this show, Lior, as you know, talk about them a bit. So we'll get to our first phone call from the radio show right now.
The firm I work for is moving from, and I just want to know what my obligation is to go the distance.
How much more travel time you'd have every day?
Oh, it's more than double.
And it would also interfere with your childcare obligations.
I would have to put them in an after-school program.
How long have you worked for the company?
19 years.
What kind of a job? What do you do?
I'm an administrative assistant.
How old are you?
42.
Oh, there you go.
And this is something that I've seen and we've talked about on the show, and you're out there at home. You may face that situation where your workplace is relocating. So we talked about constructive dismissal previously. What this concept applies here too. If your job is going to change in the sense that now you have to commute more, you have to travel more, it's a different location, constructive dismissal comes into play. So, of course, the question always becomes, well, how far is too far if the company is relocating before it's constructive dismissal? So you may be surprised that it has nothing to do with distance, kilometers, or anything like that. It has to do with how it impacts you. So generally speaking, if it increases your commute by more than an hour, if it impacts you in any other way, in a significant way, it's a constructive dismissal. Well, for this person, this lady that we just heard from, it doubles her commute, it impacts her childcare. That's a big change. So what we're looking at there is a constructive dismissal. Same with you at home. If your job relocates, it could absolutely be a constructive dismissal, meaning you can treat that as a termination. So if we know that this lady has been constructively dismissed, the question is, how much severance is she owed if she chooses not to accept this change? Well, of course, we know what to do. We're gonna go to pocketemploymentlawyer.ca. We're gonna use our severance calculator tool to find out how much severance she's owed. You could do that at home for yourself. Just go to pocketemploymentlawyer.ca, and let's see, John, how much that gets us. So we know that she's been there for 19 years. She's 42 years of age. She hasn't received severance because the company's saying, well, we didn't terminate, we just relocated. We know she's owed severance, and we can see right at the bottom there, she's owed anywhere from 18 to 24 months pay. Obviously, if her income is $50,000, that could be as much as $100,000 worth of severance debt she is owed. And again, she wasn't let go, but because of that relocation, those are her entitlements. Same with you at home. If you're facing a significant workplace relocation, constructive dismissal should come to mind. Either call me or go to pocketemploymentlawyer.ca.
Yeah, it's so interesting because, as you said, it's up to the individual in the individual case. If you had two people, say you and I, working at that workplace, and they relocate, you drive to work, it's another 20 minutes for you, but I got to take 3 buses now to get to work. That's a very different effect on both of us, right?
Yeah, absolutely. And I once had a case where my client was an older lady. She did not have a car, and that's exactly what happened. The distance wasn't too far where the company relocated, but for her, it meant instead of walking 10 minutes to work, she had to take 2 buses, and it'll probably take her an hour and a half. each way. That's a big deal. So it's a question of how it impacts you, not how it impacts someone else, and not the distance in kilometers. If it's not a big deal, okay. If it is a big deal, constructive dismissal should immediately come to mind.
In addition to helping thousands of people every year, doing the TV shows, doing the radio shows, being a family guy, Lior also does live streams on Facebook and YouTube. You want to tune into those at ST Lawyers, at ST Lawyers to find out. I want to get a question from one of the live streams. Lior, goes like this, says, I worked part-time for almost a decade at a grocery store and was recently let go. My manager informed me I am not entitled to any severance as I was a part-time employee. Is this true?
Gosh, John, certainly a big misconception out there about part-time employees that somehow they don't get severance. So let's be very clear on this, okay? Very important. You absolutely get severance as a part-time employee. In fact, you get the same amount of severance as a full-time employee, and it's calculated the same way. Part-time, full-time, seasonal, or otherwise, if you had a job and you lost that job, you are owed severance. It's as simple as that. So definitely this part-time employee at a grocery store can get severance. And just like everyone else, that severance can be as much as 2 years of pay.
Again, pocketemploymentlawyer.ca, a great resource for these types of questions. That and things like, I'm full-time, do I get overtime? All these types of questions can be answered. Or simply a phone call. Want to get to what you need to know about temporary layoffs? That's coming up on the other side of the break. In the meantime, write the number down, 1-855-821-5900, help@employmentlawyer.ca. And we'll come right back with lots more of the Employment Law Show. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thank you so much for hanging in with us during that short break. We are back at it. I want to get to a topic for the day. First, I'll give you some contact information. Again, you can keep it with you, 1-855-821-5900. That is the way to reach Lior and his crew anytime. help@employmentlawyer.ca is the email address we often refer to. But very important topic. In fact, we've talked about this for many years on the radio show and this TV show, Lior, and it was always probably equally as important to everything else we talked about. But over the last 2 years, this one has risen almost to the top, I would say, and that is what you need to know about temporary layoffs. Here is the first question, first point. An employee does not have the right to place an employer does not have the right to place an employee on a temporary layoff without consent. Can't just do it.
So there's something very interesting that happens generally, and that is if something is done often and it's widespread, it's easy to believe that it's okay, or in this case, that it's legal. And a temporary layoff is a great example of that. Temporary layoff has been such a common thing, especially over the pandemic, over the past few years. Probably half of the population at some point has been laid off temporarily over that period of time. So it's easy to assume that just because it's done and you know people that have been put on a temporary layoff, well, then it must be legal. Well, no, it's not legal. And the fact that it's been widespread does not make it legal. It just makes the wrong that much greater. So let's be very clear. An employer, in most cases, does not have a right to put an employee on a temporary layoff. So an employer that does that is breaching the terms of employment. And if you think about that, let me give you an example, John. This is an example that I like. Well, if the employer reduced someone's pay by 50%, we would already have a sense that that's wrong, right? How can you reduce my pay by 50%? Sure. That can't be right. Well, what's a temporary layoff? A temporary 100%. Layoff is a reduction of pay of exactly 100%. Yeah. Okay, not 50, not 70, not 90, 100%. So certainly if that 50% reduction is not appropriate, neither is the 100%. So anytime an employee is laid off temporarily, almost anytime, we'll talk about some exceptions, then that employee has a right to treat that as a termination, as a constructive dismissal. So just because it happened to you, your colleague, does not mean that it's legal. In most cases, no, it's not legal at all.
We talk about on the show as well, Lior, as it pertains to this topic, how important employment agreements are. That piece of paper or several pieces of paper can be so wickedly important to your work life. And that brings up our next point, that is employment contracts can contain language that gives the employer the right to implement a temporary layoff. You've got to watch out for it.
Exactly. So an employment agreement can change things. So a temporary layoff is not legal, I've already said that, unless you've given your employer the right to do it. And you can give them that right by signing an employment agreement that says so. So when you started working, or at any other point, if you signed an agreement that says, we, the employer, have the right to put you on a temporary layoff, if that's what you signed, then guess what? Then your employer can't put you on a temporary layoff, and depending on that, on the circumstances, that layoff can last as much as 34 weeks. So that's a huge problem, okay? And certainly not something that you want. You have to be very careful with what you've signed. Now, it's not common to see agreements that say that, but it does happen, and you may not realize by signing something like that you're giving up rights. So if you're just accepting an offer, if your employer is presenting you with an agreement, watch out for language giving the company the power to lay you off temporarily. You shouldn't agree to that because, again, otherwise, company simply can't do it.
And as an aside, you know, if you get one of those agreements, a fresh one or otherwise, always before you sign it, send it to Lior, let him have a look at it, and he'll comb through it to make sure it's above board, or there's red flags in that one for sure. We're talking about everything you need to know about temporary layoffs. Number 3, employees that agree to a temporary layoff have given their employer the right to do so again and again and again.
So I've already said that an employer does not have a right to lay off someone temporarily. An employee does not have to accept it. But certainly an employee can choose to accept a temporary layoff. Obviously, you can choose to accept something that your employer doesn't have a right to do. But the problem with that is by accepting even that one temporary layoff is that now you've given the company, the employer, the right to do it again and again and again. So you want to be the good soldier, you accept that temporary layoff, you come back to work a few months later when you're called back to work, okay, and you think that's it, we'll never think about this again. Well, not so fast. Because you accepted that temporary layoff, the next time it happens, if it does, you won't be able to do anything about it. So you may find yourself in a situation where you work for a few months, you're laid off temporarily for a few months, back and forth, back and forth. And that's certainly not a good thing. That's not something that you want. So you have to be very careful. I would certainly urge you to strongly consider saying constructive dismissal and not accepting that first temporary layoff to avoid problems later on.
And finally, another point here, Lior, about temporary layoffs. A temporary layoff can be treated as a termination, and employees can pursue their full severance entitlements.
So you've listened to what we've been saying on this segment, and you've decided, no, I don't want to accept this temporary layoff. It doesn't work for me. It's not right. I don't want to accept a 100% reduction to my pay. So what does that mean? That means that you can choose to treat that temporary layoff as a termination of your employment. Now, your employer may say, no, we're not terminating you. We're just putting you off for a while on a layoff. Doesn't matter what they say. You, the employee, can choose to treat it as a termination of employment. That means you get your severance, depending on the usual factors. That could be 2 months. That could be 24 months. That could be anything in between. You can always go to pocketemploymentlawyer.ca to calculate your severance. But that's one of the options that you have. So if you're put on a temporary layoff, before you do anything, before you say anything to your employer, before you go back to work if you're called, you got to give me a call. We got to do this right. We got to assess your options and what you're owed. Let's do this correctly.
I want to get to a phone call here in a moment, Lior, but I'm thinking, you know, if you work for an employer, or maybe it's a friend, maybe you just love where you work, and it's like, you know, you want to be a team player. Okay, I guess I can be off for a few weeks if it's going to help the company along. But you don't want it to be a permanent thing that they can go to again and again and again. Can you get that in writing, saying, I'll do it for you this one time because I'm a nice guy, but I don't want to do this ever again? Is that possible? Is that legal? Do they have that mechanism?
Yes, but you would really want your employer to say that they acknowledge that by you accepting this one layoff, you're not accepting future layoffs, and they probably are not going to do that. So I'm not too keen on that. I think that the better approach is to assume that if you accept that first layoff, you've opened that door, you've cracked it open, and now your employer can do it again in the future. If you don't want that to happen, you have to consider constructive dismissal.
You bet. EmploymentLawyer.ca, that's the website again. Find a radio station in your community that carries our show on a weekly basis. You'll love it. You can call in and contribute as well. Want to get to our second phone call from our radio show now, Lior, and talk about it a little bit.
I had been working at a restaurant for about 3 years. There was an ongoing issue with the chef basically verbally abusing me. The owners knew this was going on. I talked to them about it. They decided to do nothing. I didn't even speak to him. So it got to the point where it continued, eventually had enough, and walked out in the middle of my shift. And so I was given a call the next day. They said that they would consider that my resignation, not to come back to work.
They've done nothing right here.
They've dropped the ball again and again, and everyone has the right to work in a harassment-free work environment. It's one of the most basic employment law rights that we all have. Okay, and our courts, our human rights tribunals, our legislatures have all said that and made that very clear. That means that an employer that knows that an employee is being harassed has to take that seriously by law. Take it seriously, investigate, and fix the problem. Not ignore it, not sweep it under the rug, not say boys will be boys. That is nonsense, and it's illegal. So if this employer didn't actually do what it was supposed to do, and as a result, this employee said, well, I'm not going to continue working, and they left, that's not a resignation. If you leave because you're being harassed and your employer is not doing anything about it, you haven't resigned in the eyes of the law. Your employment has been terminated. You're not leaving because you don't want to work there anymore or because you found another job. You're leaving because your employer is not protecting you. So that's a termination and not a resignation. Of course, you always have to be able to prove the harassment or prove that you've talked to your employer about it. So always have things in writing. But if you leave in that situation, that's not a resignation. Although best advice I'll give here is this. If you are frustrated because of the harassment, before you leave, before you say, that's it, I'm gone, let's talk. Because we may want to do this in a different way. We may want to ensure that your rights are protected. But resigning because of harassment in the eyes of the law is, in fact, a termination of employment.
In this particular scenario, there would be, I assume, because it's a termination, there would be severance, but there would be human rights damages as well, I can imagine?
If he was harassed because of his age or disability or race, ethnicity, then absolutely, yes, there could easily be human rights damages. And oftentimes those things go hand in hand. So there could be very significant entitlements that are owed to this employee.
A phone call is coming up, but after the short break, so we'll get to that right now. In the meantime, I'll give you that contact information again. 1-855-821-5900, help@employmentlawyer.ca. That's the email address, and we'll continue with the Employment Law Show. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, thank you so much for sticking around with us. We hope you join us every week on this show. So much to be learned, and you can reach out afterwards to Lior Samfiru, co-founding partner, Samfiru Tumarkin LLP, the most positively reviewed law firm in the country. You're in good hands. 1-855-821-5900. help@employmentlawyer.ca and just employmentlawyer.ca, as I mentioned previously, to find a radio station across the country generally that carries our show. Phone call number 3 from the radio show. Lior's coming up now.
Been with my employer for 23 years. I was brought in last Thursday, told that my service no longer be rendered.
23 years. How old are you?
I just turned 48.
What did they offer you?
They're offering me 1 week for every year.
So 23 weeks pay?
That's correct.
What did you do there?
I was a supervisor at 65 employees under me.
Okay.
Man, that's a wrongful dismissal if there ever was one. But I said wrongful dismissal. That does not mean that the reason he was let go is not appropriate. You know, he said he was let go for no reason. Whether there was a reason or there really wasn't, ultimately doesn't factor in from a legal standpoint, because an employer can let you go for a good reason, not so good a reason, no reason, and as long as they pay proper severance, well, they've met their obligations. The problem is, and in the vast majority of cases, like with this guy, which I'll talk about more in a sec, the severance offered is not even close to being appropriate, and that's a wrongful dismissal. If you're not offered or paid the proper amount of severance, which happens in 90% of cases, that's a wrongful dismissal. So we know that this person was let go in a supervisory role after 23 years, was offered 23 weeks. Is that enough? Well, I hope by now our regular viewers are completely shocked and know that it's not enough. It's not even close. He is owed significantly more. But you know how I like to do this. I like to show you the calculation. Let's go to pocketemploymentlawyer.ca. We'll use our severance calculator tool again, and we'll see what that gives us. So we know, again, supervisor, been there for 23 years. That's a long time. 48 years of age, was offered 23 weeks, which is frankly ridiculous. You see why it's ridiculous, because at the bottom of the screen, you see the result. He's owed 18 to 22 months of severance. 18 to 22 months, and by the way, could easily be as much as 24 months as well. So up to 2 years of pay instead of 23 weeks, which is less than 6 months pay. So that's why it's a wrongful dismissal. He's owed significantly more, and he should never, ever accept that bad an offer.
I want to get a question here quickly from terminationquestions.com, yet another free and anonymous website you can use anytime to reach out to Lior and his team. It says right here, I was originally hired on a contract for 1 year, and it has since been extended twice. I've now been at this company for almost 4 years. Am I an employee even if I keep signing new contracts? Great point.
Absolutely an employee. And we see this often. New contracts keep getting signed. What does that mean? Does it really matter? No. Once you sign more than a couple, so you're 3 or more, you're considered a regular employee. You have the rights of a regular employee, including the rights of the right to get your full severance if you are let go. Oftentimes I see this, John, with private schools. You have a teacher signing a new agreement every year for the school year. Then at the end of the school year, they sign another one for the following one, and round we go. Well, what happens after 7 years, as an example, if that company or that school says, this year we're not going to renew, we're just simply not going to give you a new contract? Fair enough, they can do that, but they have to pay full severance because of the fact that after about 3 contracts, this person is a regular full-time indefinite employee. So for employers, it makes no sense to do that at all. If you have an employee, hire them indefinitely and deal with the termination if you have to. Having them sign new contracts every time is a waste of time, and in fact, you do something bad. It becomes counterproductive. As an employee, you can ignore those contracts after a while, and of course, if you're not sure, should you sign, should you not sign, and what it all means, hey, here I am, give me a call, happy to help.
So that severance from 7 years doesn't go back 4 years from after the 3rd contract, it covers the full 7 years from day one?
The full 7 years. So wow. After 7 years, he could easily be owed 8, 9, 10 months of severance, even though he was quote unquote on a contract. That's why we need to do this right and never walk away from your rights without making that phone call. You may be really surprised to learn what you're owed and what the law can do for you.
Again, terminationquestions.com is where that particular question comes from. You can use that anytime. Now that we're just about ready to wrap it up, here's the contact information one more time. If you got a pen, good on you. If not, we'll be back again. 1-855-821-5900, the number you can always go to. help@employmentlawyer.ca is the email address, and simplyemploymentlawyer.ca, the firm website with the media tab to catch the radio shows as well. Thanks for sticking around. We'll catch you next time on the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.